Good afternoon for all those who are listening here. I'm attorney Demario Solomon Simmons, and I'm here with a couple of members of my fantastic legal team, and we're very excited today to talk about the order we just received from our judge, Judge Caroline Wall, in our Tulsa Race Massacre case. This order is something we've been waiting on since our historic hearing back on May 2nd, 2022. And this order gives us the framework of how we get to move forward. The first thing, the first thing I want to say is we want to thank everyone, particularly this community here in Tulsa and the Greenwood community. Have you supported this team as we've been working on this issue, this particular litigation, for about 3 years? And I want to thank you so much for showing up at the court hearings every time we ask you to, showing up at our prayer rallies, coming to our town hall meetings, sending in your prayers, sending in your donations, and just telling us to keep moving forward despite all the odds, obstacles, and opposition that we have endured during this time period. And also, I think it's important that we say that we got to this point over a year after the 100-year centennial, when so many people were talking about Tulsa, but we're still doing the work. And what does that work mean with this particular order? This order, although we didn't get everything we wanted, and we're going to talk a little bit about that, but this order allows our three living survivors, Mother Viola Fletcher, 108 years old, Mother Leslie Benefield Randall, 107 years old, and our good friend Hughes Van Ellis, we call him Uncle Red, 101 plus. These three survivors, they have the ability to move forward with our case, and for the first time in 100 years, over 100 years, we have an opportunity to prove that the massacre that happened on May 31st, June 1st, 1921, created a public nuisance here in Tulsa, and that public nuisance needs to be abated. This is a historic win for our community. It's a historic win for our survivors, and it's a historic win for racial justice advocates throughout this country. As we see these things happening, as we build off the momentum of even what happened in LA with Bruce's Beach, we're going to have an opportunity to continue to create history, and we're so thankful for that opportunity. And I also want to thank my team, some who are here and you're going to hear from today. But this is just a small portion of the Justice for Greenwood team that has been working tirelessly on this issue. And I'm so proud to be a part of this team. I'm so proud to work with these men and women who are working hard every single day, trying to get justice for Greenwood and restore what was destroyed by the Tulsa Race Massacre. Now, before I bring in Michael Schwartz, I just want to say to our community and our supporters, this is a historic day, but we have a lot of work to do. We have a lot of work to do to get to the end goal, which is to have this nuisance abated. So I'm just telling you to stay with us, continue to pray with us, continue to stand shoulder to shoulder and fight with us. We have a long way to go, but this has been a 101-year-old fight. We can get there together. I have no doubt about that. We can get there together. And so with that, I want to ask my good friend and co-counsel Michael Schwartz from Schulte, Walton Zabel to just tell us a little bit more about the particular case and how we're kind of going to be moving forward. You're muted, Michael.
Thank you, Demario. I want to emphasize about how incredibly gratified we are by the court's decision. As Demario said, this is a landmark ruling. It allows us not only to file the papers in court, but to take the next step that nobody's achieved before in taking discovery, taking documents, taking depositions, and getting to the root of what actually happened in the massacre. So we are celebrating that. We are thrilled about that. And we are very focused and dedicated on moving forward immediately. As Demario mentioned, there were certain aspects of the decision that we were not as happy with. There were certain claims that the case was narrowed in certain ways with regard to certain plaintiffs, and we're disappointed about that. But we are studying our options right now. We're considering whether we take any additional steps with regard to that. But we are mindful that the three plaintiffs that we have, the three living survivors of the massacre, are all over 100 years old. And we owe it to them, the community owes it to them, to move forward as promptly as possible. And one of the key things that we can talk about today is, notwithstanding some of the plaintiffs that were not permitted to go forward in the case. The core of the case remains alive. The core remedies that we'll be seeking remain alive. And this case is very much the case that we brought, and it took 3 years to get here to. Now, there again, we are considering our legal options, but we are also mindful that it's taken us 3 years from filing our initial lawsuit to getting permission to start taking discovery. So I think our focus and our mission is to now move quickly with our very talented team and move forward in taking the discovery that's going to lead us to our goal of winning this case. Eric Miller, Professor Miller, would you like to go next?
Sure. Can you all hear me?
Yes, sir.
Great. So I just want to put where we are in some historical context. So as Demario and Michael pointed out, this case is essentially 101 years old. And even though we filed the public nuisance case just 3 years ago, for over 101 years, the survivors of the Tulsa Race Massacre have tried to move forward in court against the city and the county and the sheriff. And this order is the first time that a survivor, and in fact 3 survivors, have managed to move to the merit stage of holding the city, the county, the sheriff, and the Chamber of Commerce accountable for the Tulsa Race Massacre. So we're going to conduct discovery, and then it will be on to hearing the merits of the litigation. It's taken over 101 years for a judge in the state of Oklahoma to say that the victims of the Tulsa Race Massacre of 1921 can proceed to discovery and a hearing on the merits. Lawyers, including John Hope Franklin's father, Buck Franklin, tried in 1921. They were hounded out of court by a legal system too prejudiced to hear their claims. In 2003, a group of lawyers headed by Charles Ogletree, Adjoa Ayatoro, Johnny Cochran, and of which I was a part, represented 150 survivors of the Tulsa Race Massacre who sued the city and the state of Oklahoma in federal court, and the federal courts refused to hear the merits of that case on a legal technicality and refused to proceed to discovery or to the merits. Judge Wall's opinion means that under our current case, the last 3 living survivors of the Tulsa Race Massacre of 1921, Mother Fletcher, Mother Randall, and Hughes Van Ellis, can proceed forward to discovery and a hearing on the merits of this case. And that is significant progress over anything that's happened over the last 101 years. And I'm just very pleased and proud to be part of a process that has got us this far, finally to being heard on the merits.
Thank you so much, Eric. We will have opportunity to take some questions and a few questions and answers. But before we do that, I just wanted to convey, I spoke with the survivors. I've spoken with the survivors, and they're very excited about this opportunity. They are sad to know that the other descendants, other plaintiffs, did not get an opportunity to move forward this case. But I've also spoken to those plaintiffs and those descendants who've been dismissed out, and they were saddened that they were dismissed out, but they are still very excited and heartened by the fact that we are moving forward and that these survivors can represent the entire community of Greenwood and represent what was lost and what can be restored by this particular litigation. So I just want to lift up those survivors, those descendants, and the church, Vernon AME Church. I want to lift them up, that we still appreciate them, and we love all descendants and everyone that was impacted by the Tulsa Race Massacre, that this litigation is for all of those people. We have 3 survivors that's leading that charge, but this litigation and the remedies that we will seek, the abatement, will be for the restoration and the rebuilding of what was lost because of the massacre. So with that, you see Kenny and Kim on the screen. Just making sure that you guys wanted to chime in, or Randall, if there's anything that you wanted to amplify before we take any questions or take any questions. Okay, good deal. Well, I don't know. Have we received any questions, Dea, offline? If not, I haven't seen any come by, come on the screen.
We have one question if you would like to reiterate the ways that the claim was narrowed or restricted.
Sure. Michael, you want to take that question for us?
Yes. So basically, the court sustained and let go forward the part of the case that talked about the public nuisance that was caused by the massacre, and any remedy that results from what the destruction that took place during the massacre is in the case. So, for example, the hospital that was in Greenwood, the movie theater that was in Greenwood, those things were destroyed and they've never been repaired. That's the core of our suit, and that's the core that goes forward. There were things that were included in the complaint about the ongoing actions by the various defendants, including redlining, some of the discriminatory actions that took place during the course of the ensuing 100 years. The court took those out of the case, but left the court. But we had pled in our case that was a continuation of what started with the massacre and continued to present day. Our core theory was the massacre itself was a public nuisance. And the analogy that we used in the court and is based on firmly established Oklahoma case law is that longstanding nuisances, like there's a case that we cited with oil in the ground. That oil is sitting there for 70 years. It still needs to be cleaned up 70 years later, even if nothing was done in the interim. And that core theory has gone forward. The things that were knocked down and destroyed, the homes, the properties I mentioned, the hospital, et cetera, those were destructions of properties that constitute a public, well, we will prove constituted a public nuisance. That's still in the case. And that's what we're seeking a remedy for. But some of the intervening acts that happened during the ensuing 100 years, those are out of the case per se. But they still may be relevant to our claims, but they're not the basis of the claims going forward. So they may be subject to discovery, but they're not the claim itself.
Yeah. Thank you for that, Michael. And I would just say to amplify what you said, that those things are still relevant. We still believe very strongly, just as the city of Tulsa stated, that the impacts that we see today in Tulsa is a direct result of the 1921 Tulsa Race Massacre. So although those things are not technically in our case any longer as a particular claim, those things are relevant to discovery, we believe. And Michael made a great point when he talked about the example of the oil in the ground. If you go on Greenwood right now today, you walk down Greenwood, you will see plaques. You will see plaques that says things like H&H taxi cab service, destroyed during the massacre, never rebuilt. That is a direct evidence of a nuisance that was created. That was property that was destroyed, that was never rebuilt. Those are the type of things that we will be really digging into as we're talking about land ownership and so many other things. And that's why I cannot say it enough times. This is truly historic. First time in this nation's history that an event of racial race massacre that happened 100 years ago to Black people is going to be properly investigated with proper discovery and a proper litigation. First time ever happened right here in Tulsa, Oklahoma, related to the Tulsa Race Massacre. Truly, truly a historic situation. Hey, Dea, I got a text message from a reporter that said they had some questions, but they don't know how to get them to us. What's the best way for people to send their questions in? You on mute. I thought they just be inside the StreamYard and they.
I thought they would be able to drop them in here as well.
Well, I got one text.
Sure.
I got one question that was text to me, and it was specifically talking about were we surprised that Vernon AME was let out of the suit because it's the same church? Eric, you want to answer that for us? Or Randall, you haven't said anything. Randall, why don't you answer that for us?
Hey, I'm sorry. I was reading the comment section to look for questions. What was the question you just read?
The question was, were we surprised or disappointed? Obviously, we're disappointed, but surprised that Vernon AME was dismissed out of the case based upon the judge saying it was not the same legal entity.
Yeah, I think we were surprised. So that's really a technical finding by the court, and so we think, what the basis for standing is whether or not a particular person or entity or anything that's recognized under the law has faced an injury, and the exact legal status or the exact legal incorporation status of that person shouldn't be decided, we think, on a motion to dismiss. We think the court obviously could have taken discovery on what happened with the church before its incorporation status. Is this the same group of people? Is this the same entity? And we think that would have been appropriate to decide during the case, but to decide before we even got there, we were disappointed and surprised to see.
And I'll just add, that's among the legal issues that we're studying right now. And again, as I mentioned, it's a careful balance between, it's taken us 3 years to get here, and we want to move forward as expeditiously as possible. So we just got the decision yesterday. We're studying that and other things, but we're also mindful of, again, the 3 survivors' ages and the need to really move quickly.
Okay, another question I've been texted is, we've been asked about, in the order, the judge talks about that the preliminary abatement plan that we put together, which we think is absolutely necessary to rebuild Greenwood, but the judge tells us in our order that we have to put forward a different plan. The question is, what other type of relief are we planning to put forward? I guess I'll answer that first and then let anyone else expound upon that. Is we're still reviewing that because we just received that information just last night from the court. So we're still in deliberations as a legal team on those aspects of what we will replead, but we feel confident that we can meet the standards that's necessary. And anybody else that wants to chime in on that, please do.
I'll just quickly jump in. So we said at our 2 prior hearings that to a large extent, the determination of the abatement plan was going to have to depend upon discovery. And so the whole point of discovery over the next few months is going to be to consult with experts and also depose the city, the county, the Chamber of Commerce, the Sheriff's Department, and so on, to find out exactly just what the continuing injuries are, and then formulate an appropriate abatement plan to deal with that. So to the extent that we need to think of an abatement plan, that is going to be fine-tuned through the discovery process and consultation with experts over the next few months.
Have you received any?
Yes, we have more questions for you all. All right, so what is the timeline for moving forward?
So the judge has given us to September 2nd to file our amended petition. We are going to, as Michael keeps iterating, we're going to hopefully get that done even sooner than that, because we do recognize that we have 100-plus-year-old clients who've been waiting 100 years for this opportunity. So we're going to be moving very, very quickly to meet that deadline. Our goal is to meet it beforehand. And then once we file our amended petition, we're going to be moving forward with discovery. I mean, we actually have already asked the court back on July 1st, I believe it was, to allow us to already start with discovery or deposition of Uncle Red, which we look to do in the next couple of weeks. So we're ready. We're ready to move forward, and we're ready to get this case to a resolution as quickly as possible.
Good deal. Would there be a court date that comes in before or after the September petition filing? Do you know of that?
No, we don't have a court. We won't have a trial date, I think is what people are asking. We won't have a trial date yet. What we can do once we make that initial new filing, we can get what's called a scheduling order. Don't want to get down into the weeds. We get a scheduling order at that point that we can agree upon how long discovery should last, and then when we should have a trial date.
Okay. What can our community here in Tulsa do in the interim? And I, of course, would like to open that up to include what can national communities do as well. I
feel like I'm doing all the talking here, but I'll take that one also. Number one, for us, our community locally, continue doing what you've been doing. I can't overstate how important your support and your presence has been throughout this process. And I'm not even just talking about the 3 years since we started working on this particular litigation, but over the last 100 years. I want to make it clear that what we're doing, we're just standing on the shoulders of so many people that started fighting during the night of the massacre. People in Greenwood fought to protect their properties and their lives and their livelihoods during the massacre. They started fighting the next day after the end of the massacre, filing lawsuits, fighting to tell the truth. And we're just a continuation of that work. And so this community just needs to continue to show up, continue to participate in our meetings, our town hall meetings, continue to sign up for our newsletters, continue to show up at our prayer rallies, continue to send your donations, and continue to send those notes that we receive periodically from people around the community and the nation. It means a lot when you're working against an entire power structure that has put its entire 100-year history behind crushing and destroying a particular people in a particular location. When you have people saying, we stand with you. We have people say, we love what you're doing. We believe in what you're doing. And sometimes we get donations. It may be $5 or $7 or $10, but it just means someone is thinking about us and they want us to be successful. So continue to do those things and continue to contact the elected leaders of Tulsa and say, why would you make these 3 survivors go through this litigation when you know the massacre happened? You know a nuisance is still there and you can fix this. Don't make these people have to go through this entire litigation. They've already waited too long. Those are some of the things I think those who want to support us both locally and nationally can do.
Good deal. We do have a couple more questions. What are the plans to preserve the existing business representatives or tenants that are still present in the historic Greenwood Black Wall Street neighborhood?
I don't know if I quite understand that question in the context of our litigation, but I will say this. We believe that, again, what is happening now in Greenwood is a direct result of the Tulsa Massacre. A part of our discovery, a part of our plan has always been, and we've already been doing this, is to talk to those who have been impacted by the massacre. So if that's someone that is a current tenant on Greenwood, or someone like Mother Randall who had their home taken during urban renewal and sent out north to be oppressed even further. We understand that the judge said we can't bring those type of things, particularly in the case, but that information is still important to our nuisance claims.
Yeah, and I'll amplify. I'm not sure if it's answering either, but we have a public nuisance claim, and the public nuisance claim is based on the destruction and criminal acts done by the city during the race massacre. And the remedy that we're seeking is what's called legally abatement, but it's basically restoring the property or the situation to where it was before the massacre took place. And so a lot of that restoration is obviously Black Wall Street, the Greenwood district, the way it was before the massacre. So it does interact with the community and the merchants in that way.
And we have one more question, excuse me. I know you mentioned that the defendants were dismissed. Was there any rationale given?
Well, yes, Randall, you want to take that?
Yeah, the rationale was that they didn't exist at the time of the massacre. We disagree with that position because public nuisance is supposed to apply to anyone who's causing the nuisance or effectively inherits the nuisance. So if someone is a successor entity to an actor who caused the nuisance, then they should still be in the case. But 2 defendants were dismissed. That's correct.
And those 2 defendants are the Tulsa Metropolitan Planning Area Commission and the Tulsa Development Authority. Okay, I have another question that was texted to me. This is the question. It's from Amy I think she's with the local Fox affiliate. She may be with the local ABC affiliate. Is the amended petition that Michael is referring to, what is he saying we're weighing as our legal options? Are we still deciding to push back to try to get the Vernon and the other descendants back into the lawsuit?
Yes, that's what we're considering. We're thinking about that. We're weighing, and Randall has laid out some of the issues we see with the decision. But the overriding message is we think this is an excellent decision in terms of allowing the case to go forward. And so like anything in life, there are choices that we have to make, consult with clients about, and decide what is the best path forward. Again, these are very unique circumstances with clients of this age who've been waiting over a century. It's really unimaginable to seek justice. And so we just need to factor in what we think are actually good, strong legal challenges to certain aspects of the decision with the other issues that I've mentioned before in terms of our desire to move forward, our need to move forward given the age of the survivors in this case. But this decision came out last night. We're talking about all these things, and there is a core to the case that is incredibly meaningful and important, and that we very much want to act on immediately. And if we pursue some of these other options, it may or may not. And that's one of the things we're looking at, is whether we can both proceed immediately with the core of the case and also perhaps petition the court to reconsider some of these other aspects that we think weren't quite correct.
At this point, can the defendants appeal this ruling, thus delaying the case?
They could seek to appeal the ruling, but if they did, the case could still go forward, and that's going to be a decision for the judge. If there's an appeal, for the case to stop, the judge would have to issue what's called a stay to stop the case from going forward. We are hopeful that if there is an appeal by the defendants, that if the judge allows that appeal to go forward right now, she needs to certify that appeal, that she still allows the case to go forward in light of all the circumstances that we've laid out before. I mean, it's taken us 3 years from the initial filing of the petition to get where we are now, and to then stop things right when we got into the courthouse doors for an appeal and to wait until it comes back. That would be a severe denial of justice. It would be really kind of unimaginable if the case were to stop and we'd wait for the appellate process to play out. So this is something that the court's going to have to decide. If there should be an appeal, we're hopeful the city and the other defendants do not appeal. But if that should happen, we will press very hard for the case to go forward while the appeal, if there is an appeal, does.
I just want to add on to that. Obviously, us lawyers and people say all the time, justice delayed is justice denied. And this is the greatest example of that. And I have no doubt in my mind, right, that the defendants would love to continue to delay this case with these elderly people because they don't want them to get justice. But as Michael has stated, I think the court is very well aware of how old our clients are and how long they've waited, not only for their entire lives, over 101 years, but through this entire litigation. And so I think it'd be a manifest injustice for them to get to this level, and then there'd be a stay put on the case and have to wait for another 2, 3, 4, 5 years while it goes to the Oklahoma State Supreme Court, the appeal process. So obviously that's a decision that Judge Wall has to make. We will certainly be adamantly saying that we need to be able to move forward with discovery while we can. And we hope that will be the decision that she will make, but it will be her decision, Judge Wall's decision.
Yeah, and as Demario said, Judge Wall has been sensitive to our clients' ages. We very much appreciate her sensitivity in that regard, and we just hope that we hope and we expect, frankly, that to continue.
On the tone of recognizing our survivors' ages, we have a question. Is letting only the 3 survivors continue as plaintiffs a delay until death situation from the powers that be? If God forbid they pass before the case can finish, does that mean the case disappears and the city, state, etc. won't be held accountable?
Wow. Who sent that question in?
No name.
Well, I got a text message from, I think, because I got a similar text message question from Chris Polanansky with Tulsa NPR. So I was just wondering if it's 2 people. If 2 people.
Oh, yes, it is, Chris. Yes, it is.
Oh, okay. I was like, wow, we got 2 people saying that.
That would be quite coincidental at the same time. Yes.
Yeah, but I think people are reading in the order. Anybody want to take that? If not, I certainly can.
Well, I mean, we are preparing for that eventuality. We have made, and we don't really like talking about this. We made provisions with regard to the states of the survivors that we hope and expect that should that terrible circumstance happen, that we will have a basis to continue the lawsuit.
Yeah. And I guess what I would say to that too is that's why we believe so strongly that our judge understands the urgency of the moment, so we'd be able to move forward and get a resolution during a lifetime of the 3 only known living survivors. It will be, I mean, it'd be the most tragic scenario that people who have survived the worst massacre in the history of this country wait for justice for 100 years, wait for 2 years of litigation, finally get the opportunity, and then because of continued games and continued technicalities, they're not able to see the ending of it because of continued delays. That I don't even want to think about that. I just want to think about that we have this victory and we have the ability to move forward if the judge allows us to do it, and I know we can prove that this was a nuisance.
And Uncle Red has pledged to live to 130 if it takes that long to win this case. So there's always that.
We do have a couple more questions. Is there a stop time here for us, guys?
No. And if you have the info, if you have the media member,
Yes.
outlet, if you'll say that also.
Yes, this is another question from Chris Polanski. What is the discovery strategy? Who are you going to depose?
Well, we're not going to give you a.
I was going to say, that's a nice question.
We have a strategy. No, we have a strategy. And we have a robust and talented team of lawyers and paralegals and activists and academics. And we're going to be putting our heads together to execute our discovery plan and all deliberate speed.
Yes.
Okay. Does this suit also require an immediate stop to the targeted displacement of businesses and or residents? This is from Alfred.
Can you repeat that?
Does this suit also require an immediate stop to the targeted displacement of businesses and or residents?
Unfortunately, no. That'll be in a different lawsuit, but all of it is relevant to us. So we want to hear about that. We want to hear about what is the specific displacement that you're experiencing and how it may relate to the nuisance and this particular litigation. But we don't have at this time. We don't have any like an injunction that has been filed at this particular time. So the answer would be no to that particular question.
At this point, can we already answered that question. I'm sorry about that. Tulsa World editor, would you foresee any likelihood that the case could face another roadblock after the amended petition is filed that might delay discovery even further?
Well, I think just again, I mean, the defendants could decide that they want to ask for what's called an interlocutory appeal, ask the judge to allow them to appeal the case, and then ask the judge to put a stay on the case. Obviously, we would have to fight that, and that would take some time. And then it'd be up to the judge to decide if she wants to continue to delay these 100+ people opportunity to prove their case. So yes, that could be a roadblock. We think we can overcome that. We don't think that's fair. We don't think that's just at all. When you weigh the equities, courts have to weigh not only legality, but also equity and equitable principles. And I don't think the equitable principles would say that this case should be on a stay. But again, that's for Judge Wall to make that determination. She's the judge in this case, not us.
Understood. We have another question this one is from Kieran. Do you think the approach of a public nuisance claim would apply in the case of the massacre and coup of Wilmington, North Carolina in 1898? He or she is a descendant of one of the main victims of the massacre, Alex Manley.
I mean, that's something we'd be happy to talk to her offline. That's not something we've thought of that we want to talk about at this particular discussion, but happy to get your information, and we're happy to have that conversation with you. Any other questions from reporters or community members?
No, that does conclude the questions so far.
Okay.
We will accept questions at our info@justiceforgreenwood.org email address after this event concludes.
Sounds great. Well, guys, and Kim, anything else you guys want to say before we sign off?
I'll just say one quick thing. So in the judge's order, she's given all the rest of us or all the rest of you around the country, around the world, we're not lawyers, a set of marching orders, because she said that large part of the remedy for this is up to the county and state of Oklahoma to do on its own. And so, as Mario said, one of the major things that everyone can do is follow the judge's instructions and contact the state, contact the city of Tulsa, and demand reparations on behalf of not just the descendants, but also not just the survivors, but also the descendants and the current residents of Greenwood and North Tulsa, because even though the judge has said that resolving the problems of the descendants in those neighborhoods is beyond her capacity, she strongly indicated that it's not beyond the city's competence or capacity. And the city is engaged in fundraising exercises. Other people have as well, and I think it behooves us all to demand that those funds are dispersed to the people of Tulsa, Greenwood, and the diaspora.
Eric, I appreciate you saying that. I think if people want to look at our amended petition, in our preliminary abatement plan, we believe strongly in everything that we put in there. Those are things that you can pick one out and say, hey, City of Tulsa, today you can stop people who are descendants of those who suffered the massacre. You can abate their taxes for the next 100 years. You can create the scholarship program that should have been created. You can build the hospital that should have been built. You can provide the reparations that the state of Oklahoma said to do back in 2001 and 2003. You can do that today. Those are things that can happen by the city, by the county, by the state. So Eric, thank you so much for highlighting that, because that is so important. This is so much more than just litigation. This can be done. The question is, they know they can do it. They should do it. And I also, Eric, you talked about those who raised $30 million last year for a museum, and none of that money went to any of the survivors or descendants. That money should go to some of that money should go to survivors and descendants, and some of the ongoing revenue of the Greenwood Rising Center should go to the survivors and descendants. Right now, those are things that can be done. That don't take a litigation. That can happen. So thank you, Eric, for highlighting those issues. All right, good people. It's good to see everyone. Oh, go ahead, Michael.
No, I was going to say thank you.
Okay. But thank you. Thank you to my team once again. Thank you to the Greenwood community, our descendants, our survivors, everyone that's supporting us. Continue to support us. Continue to check in with us at justiceforgreenwood.org, 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 and Justice for Greenwood for our people. Thank you so much. Peace.